much thankful to Bihar Judicial Academy and all learned judges on this occasion of the deliberation on much important topic, that is Bhartiya Nagarik Suraksha Samhita. So without delay, let me congratulate all of you that finally in independent India we are going to have a completely Indian codified law not affected by Britishers. Because much awaited, you can say it is very prior that let me give you the brief outline of this Bhartiya Nagarik Suraksha Samhita. Because you see, this is going to come in force from 1st of July 2024. Now, there will be lot of issues which will be coming up, but let me tell you, this has been devised on Indian mechanism to meet the present need of criminal justice delivery system. Because at the time we were in the need of cyber crimes, new forms of crime were taking place, and it was all pile up of criminal cases which required speedy justice delivery mechanism. So that is why it was proposed by Government of India that it is time to have a new all codified criminal law, including all three laws which has been enacted in Indian line. So let me start with the nomenclature. Entire nomenclature is Bhartiya Nagarik Suraksha Samhita, Bhartiya Nyay Samhita, Bhartiya Saksha Adhiniyam. Now these are the primary legislation of criminal justice delivery system, and this has been done with the victim-centric approach. So within this 2 hours, we are going to see each nooks and corner of the mechanism which has been formulated. Let me give you the outlines that what changes has been made. Then we will see the insider, the section provisions, because we are not going to comment on the probable efficacious application of these sections because it is very early and it will take time, because the new reflection is that you need to have the knowledge of both the earlier CRPC 1973 Act as well as all the laws with this Bhartiya Nagarik Suraksha Samhita, because both will be applied by the judicial officers and criminal justice functionaries till the new forms of FIR and new crimes which has been devised in Bhartiya Nyay Samhita. For example, there is a cyber crime, there is a chain snatching, there is a syndicate organized crime. So number of changes are going to take place, and we are very much lucky to address and witness this live application of the law, because right now I will say this is a transition phase. Now the brief outline is that Bhartiya Nagarik Suraksha Samhita comes with 39 chapters. Earlier there was 37 chapters. So here the comparison has to be made because there are number of changes on which we are going to focus. Now what are the changes? This Bhartiya Nagarik Suraksha Samhita is victim-centric approach. Now victim has been kept at the center stage, and the best development which has been made is that there is a concept of zero FIR. Now jurisdiction has not been taken, means that now there is a no foundation of jurisdiction. Person in any jurisdiction can from any place file an FIR. Now one major changes is the witness protection scheme is in expressed form in absentia trial. Earlier the trial court had to wait for the recovery of the or surrender of the accused. Now section 356 of Bhartiya Nagarik Suraksha Samhita provides in absentia trial. So this is a very, very landmark achievement that now functionaries are no more required to wait for the accused. Then there is a change in the concept of informant. New definition, a wider definition of informant and victim has been included in Bhartiya Nagarik Suraksha Samhita. It has made the act completely transparent, accountable, because in a short while we are going to see the comparison on your screen, that will give you the notion that more than 40 editions are there in Bhartiya Nagarik Suraksha Samhita. The most important thing which I will ask, or we should take the benefit from today's session, is the timeline. The major breakthrough is to make our criminal justice delivery system a speedy justice system, time-bound trial procedure, time-bound judgment delivery mechanism. Everything has been pinpointedly drafted and accounted on the basis of timeline. So timeline is one of the aspects which we are going to see. Then the words which were not defined. For example, you might go and see the prior definition of bail, bailable offences, non-bailable offences. It was very much not clear. But now the concept and new definition has been added. Victim-centric approach has been added. Compulsory audio video recording and electronic evidences has been expressly mentioned in these sections. So the valuable input in the trial procedure is right from the pre-trial stage, trial stage, post-trial stage. There is a lot of things are going to be changed from 1st of July 2024. So now we are going to see what are the major changes which has been made. Now, if you can see on the screen, audio, video, electronic means. These are the new major additions, and again, the power of penalty has been enhanced. You can see the definition of bail has been expressly added with so much flexibility that the words are so much clear for a common man also. Earlier, there was no such definition of bail, bail bond, bond, electronic communication. So you all can see that these things has been rationalized, made very flexible from the end of the common man. That criminal justice system should support common men rather than having a very complex set of terminologies. So you see, direct use of word advocate is there. Earlier, vakil, pleader, and then we used to ask what is the difference between barrister, vakil, pleader. So to avoid these cobwebs, a clear intention has been made that only the word will be advocate everywhere. Now you can see increase in monetary limit of fine from 10,000 to 50,000 for first class judicial magistrate. Now enhancement in the power has been there in Bhartiya Nagarik Suraksha Samhita. The second is judicial magistrate second class power of fine was earlier 5,000, which has now been made to 10,000, mentioned under section 23 of B.N.S.S. Now you can see, because this is very initial, we have to discuss a lot of things, and within 2 hours I will try to do justice with this topic to cover almost all things and assure you all that you are going to take a great benefit from this session. Because see, the petty offences fine from 1,000 to 5,000 has been enhanced under section 229 of Bhartiya Nagarik Suraksha Samhita. Now why these things has been done? Because we have witnessed the 1898 Criminal Procedure Act, which redrafted into 1973 Criminal Procedure Code. Now what are the changes? What were the loopholes? Why government thought from the point of view of witness? Earlier we had a witness protection scheme since 2018, but new section, trial in absentia and witness protection scheme is expressly mentioned. Now every state government will have to formulate a law relating to witness protection scheme. Now the best part which I would like to discuss is that for the first time, criminal procedure, that is Bhartiya Nagarik Suraksha Samhita, has been correlated with POCSO, offences of rape, and there is a direct relationship between the trial which can be commended, which can be completed within time-bound manner. So these are the major development we are going to see. Now, in criminal law, the first and foremost rider is, or the challenge is, to file an FIR. Now this new Bhartiya Nagarik Suraksha Samhita has made filing of FIR very flexible. You might be acquainted with Lalita Kumari versus State of UP. Time and again, there was the challenges where Supreme Court has to lay down the guideline that in cognizable offences, FIR has to be or mandatorily registered. But now here it is very much clear that jurisdiction will not be hurdle. Place of occurrence of crime will not be hurdle. You can file FIR in any jurisdiction. That is what is a zero FIR concept, which was interpreted by Supreme Court earlier. Now it is visible. You can see, because from the topic we have to know, FIR is the first stage on initiation. You see, section 173 of B.N.S.S. talks about the zero FIR and E-FIR. Two new things which are coming is zero FIR and E-FIR. Now what is zero FIR? Suppose I am traveling in the train and somebody has done theft of my property. Then going by the law, wherever the crime occurred, within that place I can file. But here, zero FIR can be filed from any place. Now this is one of the very landmark achievement, because you see common people are very much adamant that their FIR is not being filed. They have concern from the police that they never register FIR in cognizable cases also. Now, this electronic video mechanism and online mechanism has removed the barrier of the police officers as well as the informant. And the major breakthrough is that when you get your FIR filed, you have to struggle to get a copy of an FIR. Now, a basic change which has been made, that informant as well as victim shall be provided with the copy of FIR. The domain of informant has been enhanced, and now victim can also seek free of cost copy of an FIR. Earlier there were no expressed provision that victim will get free of cost the copy of FIR. So this is again a major breakthrough which has been achieved to rationalize criminal justice delivery system from victim-centric approach. That informant is bound to get the copy. Earlier also informant used to receive the copy, but now they have enhanced that not only the informant but victim, the sufferer of the crime, will also get free of cost copy of an FIR, which is well mentioned in section 173 of B.N.S.S, which was earlier under section 154. Now you can see FIR can be registered under direction issued under section 175 clause 4 of Bhartiya Nagarik Suraksha Samhita. So earlier the 154 is converted into 175 and 173. Now these are the major comparison. You can see section 154, this is the comparison chart which I have devised, and it will be very helpful for you all when you are struggling that now which section belongs to which in new provisions. So there are more than 40 additions in Bhartiya Nagarik Suraksha Samhita. 40 new provisions has been added. You can equate that earlier there were 484 sections. Now we have 531. You can remove the saving clause, and 530, section 530 is a great breakthrough. That for the first time it mentioned right from the trial stage to the post conviction, every proceeding will go on in online mechanism. So let me start with section 530 of B.N.S.S, which is a major breakthrough, and a great infrastructure is being prepared by the government of India and on the initiative of Honorable Supreme Court. When APJ Abdul Kalam in 2007 started e-court concept, and e-court started the landmark change in Indian judicial system, Indian judiciary. Now we can have an audio-video conferencing mechanism in evidence recording. We are recording the statement from the jails also. Now a new version is that entire trial will go on online mechanism. You might have experienced during the COVID situation that the court proceedings in the Honorable High Court and Supreme Court and even in the District Court was going through online mechanism. But it has become the reality, saving the time of the witnesses. Now witnesses from their own home can appear in the court via video conferencing electronic mode. So these Section 530 is the most important breakthrough that has been achieved. Through in upcoming time it will tell how challenging it is, but Section 530 has laid down a new formulation for judicial proceedings, from trial to conviction to acquittal, because this is for the first time entire procedure is going to be online. So now you can see EFIR, the provision of lodging information through electronic communication. Now, what is EFIR and zero FIR? Now, zero FIR is that in physical mode you can go and register your FIR independent of jurisdiction. I have given you the example that any crime happens to me and I am in traveling mode. In between, I can register the case at any police station. That is considered as a zero FIR. Now, what is EFIR? EFIR, by using electronic mode, I am registering my case through online mechanism. And you can see when you will file EFIR, within 3 days that EFIR has to be formulated in the diary in the police station. Whole notation has to be put forwarded on the document within 3 days. So this mechanism has been devised. Earlier already I have expressed right of the victim. You can see B.N.S.S has introduced right of victim to get free of cost copy of FIR. This which was I was talking earlier, that now victim scope has been enlarged, because if you will see entire provision, session trial, magisterial trial, summary trial, you will find out that it is based on victim centric approach, and that is why this has been drafted, that victim has to be given preference. First thing. Second, I would like to discuss here itself that the witness, we had earlier 2018 witness protection scheme. Honorable Supreme Court in State of Gujarat versus Anirudh Singh has laid down the guideline for witness protection scheme. It was existing earlier, but CRPC was absent in expressed mechanism. Now you can see we are having a witness protection scheme expressly mentioned in B.N.S.S. Coming on to the comparison, you can see these are the arrest related provision. One more provision was a very interesting provision we have studied, arrest by private person. Now without delay, a private person will take that person if he arrests to the police. Now what was the duration of without delay? There was no comprehensive duration. Without delay may amount to 24 hours. But here it has been expressly again changed, and it mentions that if a private person under section 43 arrest, within 6 hours that person has to be taken to the police. Because a private person, when he witnesses that there is a likelihood of happening of cognizable offense, he must arrest, because it is the duty and also the constitutional mandate that it is our duty to inform police about the happening of cognizable offenses. But without delay was not defined. Now the time limit again I am mentioning is within 6 hours you have to produce that person whom you have arrested privately to the police station. Now this is again a clarity in the application of law, that you can no more detain a person for more than 6 hours. So let me bring you to this facet that you see section 157 of CRPC contains 2 subsections, which has been now replaced with section 176 of B.N.S.S, which is similar to each other. And the major breakthrough is that recording audio, video, electronic mode. Entire evidences shall be recorded in audio, video, recorded mechanism if offenses of rape and POXO are charged or alleged with. So this is again, if you will see, the major breakthrough during search and seizure was police used to keep anything in your house and they used to say that this has been recovered. Now many simple and common people were becoming the victim of the police atrocities. Now number of false and malicious cases were being filed. Now in order to come out of the clutches, it has been to set the accountability, section 105 and section 107 of B.N.S.S, which ask for compulsory audio video recording of search and seizure procedure. Now this is the one of the best thing that we are going to witness. Now even police cannot keep anything intentionally in order to frame you, because the onus is on the police that if they are going for search and seizure, it will not be in direct physical mode, but in physical mode with audio video recording. And the best thing is that when police will audio video record that search and seizure procedure, within 24 hours that record has to be sent to the jurisdiction of the magistrate. Means it is a real time information of search and seizure has to be reported to magistrate. Now this will surely lead to end of malicious and false fabrication cases where police used to keep certain unwanted things in your house and they used to say that amount, for example, some drugs, liquor, anything can be planted intentionally to frame any person. Now in order to get rid of this false cases, this is the best thing which has taken place under section 105 and section 107. That is audio, video, electronic recording of search and seizure, which we will see. Now you see again 176 has made a very salutary change. That is that offences which are more than 7 years of punishment will be investigated by forensic lab and forensic expert. Now this is a major breakthrough, that earlier we don't have such, we were not using the scientific advanced mechanism to fix the investigations in crime. Now any offenses which is more than 7 years and the charge of 7 years is there and investigation is taking place, there will be utilization of forensic expert. Now this will pave the path for completing investigation on time, transparent investigation mechanism, and use of scientific methodology and forensic labs to resolve the cases, which is surely going to change lot of things in the criminal justice delivery system. This is what is there. You can see, for bringing credibility to investigation, forensic experts have been mandated to visit the crime scene to collect forensic evidence for offences punishable for 7 years or more under section 176 clause 3 of B.N.S.S. Now, what was the earlier or present situation regarding the forensic examination or investigation? We often see that the cases which are very much in limelight or belonging to very great leaders or any person who is very much rich has asked that now I want some serious investigation, then with the permission there was utilization of forensic expert. But now for even a common man, because you can see Arushi Talwar case, there was huge installation of forensic expert and examination to investigate the case. Now there are certain cases you can count on fingertips, or you know that where and which type of cases are being investigated by forensic expert. Surely that are the case of high importance. But what about the common man? If common man suffered or became victim of crime of the offences more than 7 years, so in such case there was no provision for forensic examination or expert, unless court asks that there must be utilization of forensic expert. But now you see, this is one of the major breakthrough, that for every case having more than 7 years of offense involved will be examined and investigated by forensic expert, which will be surely getting the result in transparent way. Now, talking about the deletion, a major deletion was which has been made is the removal of word metropolitan magistrate. Now the word metropolitan magistrate has been removed, metropolitan jurisdiction has been removed, and it has been taken by first class magistrate or simply the magistrate, the term jurisdiction. Now why it has been done? Because there were certain complexities that was applicable only to the metropolitan areas. Technically, Patna also falls, if you will see section 8 of CRPC, it says about the metropolitan area, every area having more than 10 lakh population. But the notification of metropolitan area has not been done. Now it involves a complex procedure in the criminal justice system. Now why it has been removed? Because in order to add uniformity in the judicial system as well as in investigation system, that there should be uniform process, no extra process or no special process. For example, we used to hear in Delhi, in Bangalore, that there is a metropolitan magistrate. Why our state is not having? Because we were not notified. So therefore the word has been removed to avoid the complexity. Now coming to the next part, arrest provision of Bhartiya Nagarik Suraksha Samhita. As we were discussing, that section 43 of CRPC is similar to section 40. Now the best thing what you have to or we have to do is to make a comparative study. Why I am saying? Because the way we are getting the information that from 1st July everything is going to be changed because new law is going to in operation. But the reality is that old law cases will be run by old mechanism. So extra onus is on us. We have to cover both old one as well as the new one. So this is the challenge. And let me remove the confusion that people who are thinking that now only new law will be applicable. So it will take time, at least 10 years. Because the old cases which are running in the court will be governed by the old. It's not apt to say it is old because it is yet in force. So will be governed by the same CRPC, same IPC and same Indian Evidence Act. It will be applicable from the day, suppose from 1st July, new FIR is being filed under Bhartiya Nyaya Samhita. So these procedures will be applicable on that offences. So remove the doubt and be clear, because we have to know both the new one as well as the old one, because this will be also applicable and it is not a retrospective but prospective. So and it is more onus on both the judicial officers as well as all the functionaries of criminal justice system. Now who are the functionaries? Judges, court, police, prosecutors, advocate. These are the stakeholders in the criminal justice delivery system. Now coming on to this provision, you see one more, you may take it as a positive or a negative thing. Because handcuffing, so far as now, Supreme Court guideline in the landmark judgment and NHRC guideline on handcuffing. You might have seen that Article 21 provides that there must not be handcuffing because it is an old colonial legacy. But see, now there is an express provision under section 43 subsection 3 for handcuffing. Depending on the gravity of the accusation or crime, handcuffing will be expressly followed. Means police can resort to handcuffing of an accused if he is booked under the charge of murder or offense of murder, booked under the rape, or if he is hardcore criminal, then no human rights is going to work for them. There is express provision of handcuffing. Because right now, Honorable Patna High Court has also issued a guideline regarding the handcuffing, because there were a number of PILs which has been filed that handcuffing is the violation of fundamental rights, right to dignity, and certain age group, for example, child, old age person, are not within the ambit. But here in this section 43 clause 3, expressed clause of handcuffing is there, that depending on the gravity of the crime, police may resort to the handcuffing of the accused. So this is one of the major change once again that we have to see. Then coming on to the timeline factor. This is the most important factor which we have to see. That is the timeline factor. Before that, you can see new section under section 183, read with section 3 of Bhartiya Nagarik Suraksha Samhita. Now, the confession or recording of the statement of a rape victim, that is compulsorily in electronic video mode. Under section 164A of CRPC is similar to section 184 of Bhartiya Nagarik Suraksha Samhita. Now this section deals with medical examination of a rape victim. And let me here point out the major breakthrough was that suppose there is a rape victim, now their medical examination is being done. It used to take months to release the medical report by registered medical practitioner. Now this is one of the best thing that has happened, that now registered medical practitioner from the date of receiving the case within 7 days will give the medical examination report of a rape victim. Now this has been done to expedite the trial of rape victim cases. It has been done to expedite the rape and POCSO cases. Now this will surely remove the barrier of delay which is taking place, and not even delay but also the victimization of rape victim through the systems. So this, you can see that B.N.S.S solves the crisis by clearly implying the term 7 days under section 184 clause 6, thereby provides clear period regarding forwarding the report of registered medical practitioner to the investigating officer. Now, rape victim will not have to suffer and wait, because timeline has been fixed that within 7 days, registered medical practitioner is going to release the report and submit to the investigating officer. And as soon as investigating officer will receive that report, it has to be submitted before the magistrate. Now, you can see section 167 CRPC, that is the most important section that relates to the freedom and liberty, and often termed as the very important section under CRPC. Now it has been replaced by section 187. Earlier, police custody was possible only to 15 initial days, but now only judicial custody was possible. But B.N.S.S says 15 days judicial custody is possible for 40 days, 60 days and 90 days. Here addition is 40 days. Suppose police has not been able to complete the investigation within 24 hours. Now, as soon as it is done, section 187 comes into the picture. Now, it will give the judicial custody of 15 days, read with 40 days. Earlier 40 days was not there. This is addition. Earlier 60 days and 90 days. After completion of 60 and 90 days, if charge sheet has not been submitted, the person is eligible for the bail. Now 40-day period has been added and judicial custody maximum 15 days. So this is one of the game changer, that 40 days is a time that more and more chance has to be given to the police to expedite the investigation and submit its report. And even it is accused friendly also, because you see in upcoming provisions we are going to see there are a lot of things for the accused also. Huge changes has been made from both victim centric as well as accused centric, but finally the victim is the utmost sufferer of the crime. So this act has tried to balance the odi alteram partem concept, that both sides should be heard rationally. Now you see, the best part was that correlation of POXO. Now, earlier the CRPC was not mentioning any special laws. Now there is express provision under these sections that investigation of rape and POXO cases has to be completed within 2 months, and in POXO cases judgment has to come within the 60 days. Number of changes we are going to see the timeline in detail in upcoming slide. That is the most important part for all police officers, advocates and judicial officers. The timeline factor which is attached to the Bhartiya Nagarik Suraksha Samhita is the most important one. You can see the provisions relating to bail. Now, as I said, more flexible definition has been given. For the first time, the definition of bail is found in the definition clause. Then there is also clear-cut definition of bail bond, and the best part is that for the first time, the relaxation has been given to the first-time offender, because earlier there were no expressed provision for first-time offender. Now it has been expressly mentioned in these sections about, you can see, earlier the provisions of bail was under CRPC section 436 to 439. Now it has been in the new Bhartiya Nagarik Samhita, Suraksha Samhita 478 to 483. Now why I am saying this one? Because see here, the difference is section 436A of CRPC has been replaced with section 479 of Bhartiya Nagarik Suraksha Samhita. Because you see, first time offender, you can see 3 categories has been defined. Now release after 1/2 of the punishment, there is a classification. Then a person can be released on the bail if he has completed 1/2 of the punishment. The second classification is, if he is a first time offender, he is to be released on the probation. You see, application of Probation of Offender Act, section 360 of CRPC, that talks about the release of the young delinquents by admonition. Now, you might have heard that Probation of Offender Act for the young or tender age person, that they may be released on good behavior but with admonition, because you see they have a great future. They can, because there is a jurisprudence that if a young person are kept in the jail, they are surely bound to become the criminals if they are coming out of the jail, because they are living with the criminals. So there is one psychology, and therefore B.N.S.S has put more and more focus that persons should be released as if it is possible with reformative justice system. So this is a new approach of reformation along with victim-centric approach, that the focus has been given on reformation, that we will give every chance to a person to get release. Now you see, release after 1/3 of the punishment for first time offender. Now this is something very, very important highlight. The third categorization which has been made under section 479 of B.N.S.S. This is a breakthrough in the line of European style and American style of justice delivery system. Now we are giving, there is a categorization of proclaimed offender. Now who is proclaimed offender? Person who is declared criminal, has committed number of offense and absconding. So now even absconder cannot be free from the clutches of trial, because we are going to see that trial in absentia and judgment in absentia, means judgment can also be passed if person is absconding, and as soon as he will be arrested, he will be convicted. Earlier we used to wait for the person get arrested and then either acquittal or conviction. So now it has paved the path, that you see why it has been done. If you will see the drafting history of Bhartiya Nagarik Suraksha Samhita, it has taken into the account the trials in Bombay blast. Mumbai blast which took place, number of people absconded, terrorists absconded, and the trial was halted. Now, keeping in the view that even a person is absconding, trial will continue. Judgment will also be passed. Now it depends whether he is arrested or not. The trial will continue in absentia, which is one of the very important part on the term of deterrence, that you can be punished anytime as soon as you are arrested, and you will not be let off, because this is the basic principle of criminal justice system. Either put him on trial or prosecute. A criminal should not be scot-free. He has to face the trial and must be convicted if he is a criminal. So this is the basic ambit and jurisprudence that has been followed, and therefore introduction of this concept of trial in absentia. Now with bail, you see the new pre-trial procedure has also been changed. Now, three part is very important: pre-trial, trial, and post-trial. Whole CRPC or criminal law can be categorized in three parts, and it starts with pre-trial procedure, it starts with trial procedure, and it ends with post-trial. Now, post-trial involves how the prison system, how the convicted prisoners are taken into the jail, how they lead their life, what is the concept of payroll and furlough which is being given. Now it comes under the post-trial procedure after conviction. So entire criminal law is categorized in three parts, that is pre-trial, trial, and post-trial. Now every criminal case starts with pre-trial, lodging of an FIR. So we have seen that how the Bhartiya Nagarik Suraksha Samhita has rationalized by removing the hurdles in FIR through e-FIR and zero FIR. Now, what about the cases where civil servants are alleged with the crime? What are the cases where the judges are alleged with the crime? How the trial procedure will be initiated? Again, there is a change. Now, Section 197 of CRPC has been replaced with Section 218 of Bhartiya Nagarik Suraksha Samhita. Now it has taken into the account the dignity of the post, because you see the persons sitting on high post are liable to be more affected because people try to put through malicious or false cases. You have seen that if with power comes the responsibility, and as much as responsible you are going to be in the system, more and more you are on the target. So now you see it has taken into the consideration that the concept of deemed section, because you all are well aware that civil servant section 21 of Indian Penal Code comes with the constitutional post comes with immunity clause. There are certain immunities given to top brass or person sitting on higher post. Now, this section is relating to the cases and prosecution of judges and public servants. This is very important. Now, entire procedure is that if certain person alleged before initiating the case, a permission of government has to be taken. Now, in case of judges, the district judge is the authority or nodal agency from where permission has to be taken before initiating any pre-trial procedure against the judges or civil servant. Now you see this new and very dynamic concept. The idea of sovereign immunity has overemphasized and balanced approach has been taken, that such person must be dealt with all sort of line of control. Now why that is? That idea that pre-sanction is that suppose a IAS officer has been booked or cognizable offense has been alleged against an IAS officer. Now before proceeding to the pre-trial, his senior IAS officer will have to give the report. And the sanction means permission has to be taken from his senior, and then police can initiate the investigation. Now this is what deemed sanction. Police is going to wait for 120 days, and if the report is not coming up, it will be counted as deemed sanction, means accepted that they have given that, let us proceed. Now if they give the report, no, you cannot move, you cannot initiate the process, then they will not initiate the process, because that post has certain dignity attached to it, and therefore it is not that they are completely immune. It is not so, and therefore the application of section 218 B.N.S.S comes into the picture. 120 days has been given that to initiate. At least 120 days should be waited for initiating the pre-trial procedure. Now, public servant is given an opportunity of being heard regarding the situation leading to the fiasco. Now, report containing the fact and circumstances of incident from the officer senior to the public servant is to be received. Now, the report of your senior will work before initiating pre-trial procedure. I hope it is clear to all of you. This provision is very important because number of times such cases come where the civil servants or judges are involved, and it has to be dealt with section 218 of Bhartiya Nagarik Suraksha Samhita, where the question of deemed sanction. What is deemed sanction? If a report is not going to come, it will be considered that acceptance has been given. Now pre-trial procedure can be initiated. So this is one, again, a very unique set of change which has taken place. Now pre-trial procedure, you can see section 209 and 232. There is again a very important thing which has been done. For instance, if magistrate has taken cognizance under section 190. Now cognizance has been taken and it comes that it is not within the power of that magistrate. Then what will happen? Then it will be committed to court of session. Earlier, there was no time limit for committal of the cases, and huge delay used to take place. Now there is a timeline factor which is going to work, that even there is a timeline from the date of taking cognizance. Suppose magistrate has taken today the cognizance. Now he has to, because in upcoming you see under section 232 of B.N.S.S, efficient timeline for transfer of cases exclusively triable by the court of session. Now you see within the mandate complete the process within 90 days. Now within 90 days the committal procedure from the date of taking cognizance has to be taken. You can send it before, you can send it next day from the date of taking cognizance. But the time frame which has been devised is 90 days, and how much it can exceed? Up to 180 days. Now when it exceeds 180 days, you will have to write the reason for delay, that why you have taken 180 days for committal of the cases. Now again, this is why this has been done, to make trial assure the accountability factor. The trial has to be completed within time bound manner, because we all know the reality that we are having the pile or burden of huge backlogs in criminal cases as well as civil cases. Now in order to identify that we need the clearance of all the backlog criminal cases, which is burden on judiciary, and you know that delay means it's not a complete justice. Justice delayed is justice denied. So basing this key point, Bhartiya Nagarik Suraksha Samhita has taken into the account these procedural timeline factor, and the major change which has been made is basically a timeline. Addition and deletion is not very serious task, but the timeline is going to be the key factor why we are saying that B.N.S.S is very much for the victim purpose, is very much important for victim, is going to change entire Indian criminal justice delivery system, and with the positive line that we are going to see, if this timeline will be followed, the victimization will be less, and which will serve to work the criminal justice system in efficient way. So this timeline factor is one of the important point regarding the committal of the cases. Now you can see, coming on to the timeline for session trial. Now session trial earlier covered section 225 to 250. Now this new section in B.N.S.S is 250. Now you can see that provision of application of discharge. Earlier there was no provision for application of discharge. There was no provision that when discharge application will be filed. You can see that within 60 days, even in warrant trial cases, the provision for application for discharge is there. Within 60 days, it can be filed by accused. Means it is giving chance to each and every person in the trial, even in the session trial also. So this you can see that provision for application of discharge, again timeline has been attached, and that what is the timeline? 60-day timeline is there. After that 60 day you cannot file discharge application. So discharge is one of the important procedure where if there is no evidence is available, no sound evidence is available against accused, then he must be discharged, which is the rule. So here also it can be utilized, and in summary trial and session trial, magisterial trial, you can see all these things we have to cover. And everywhere the major change is timeline. Now earlier there was no provision for recording of evidence by audio, video, electronic means. Now B.N.S.S expressly provides for this audio, video recording. Now earlier there was no provision, express provision of discharge in summon cases under section 351 Crpc. Now section 274 of B.N.S.S, very, very important, because see, these are the very essential set of facts we have to remember. We need not to go in comparative sections, but we need to know the timeline factor for which this change has been made. Now you can see timeline of 60 days from the framing of charge. There was no time limit for framing of charge in session trial, warrant trial. Now again see, at present, if you will see the trial procedure, there is right now in CRPC there is no timeline. Then after how much day the trial or framing of charge must be completed. It lingers on and cause delay. And now you cannot delay because onus is on the judge that he has to act within the timeline. That if charge has been framed, so you have to do framing of the charge within 60 days. Now you see the most important highlight is section 258 of B.N.S.S. Now it is on compulsion on judges. What? Judgment is to be delivered in 30 or 45 days from the conclusion of the argument. Now what is the present status? There is no time limit for judgment. Now you see, this is a very, very important thing which has been, let me highlight this. Section 235 is similar to section 258. Means 258, section 258 of B.N.S.S. Kindly note it down, because this is a very essential set of development that after conclusion of argument, within 30 to 45 days. Now when 30 days and when 45 days? 30 days is the normal days. 45 days you will have to record the reason for delay, that why you have given judgment in 45 days, because section 258 says that after the conclusion of the argument, you have to write a judgment within 30 days. Now if you come with the judgment on 45th day, your judgment must include the reason for delay, that why you have taken extra 15 days time. So this is one of the major breakthrough that will push and compel justice delivery system in time bound manner. Judgment has to be, because one more interesting thing that is going to come up in the slide, that not only about the judgment. Now let me put to this, because this is one of the, now all three slides which I will be showing is very important. Timeline fixation in B.N.S.S. This is the major change which has taken place, and that is why every citizen of India is excited about this Bhartiya Nagarik Suraksha Samhita. And why we are going to have such deliberation, because this is the timeline factor. Now one by one we will see. Now section 232 of B.N.S.S timeline for commitment to court of session within 90. We have seen just earlier that from the date of taking cognizance, within 90 days, committal of case has to be taken to the session court. Now this is mentioned under section 232 of Bhartiya Nagarik Suraksha Samhita. Now section 230 of Bhartiya Nagarik Suraksha Samhita, supply of document within 14 days from date of production and appearance. Now earlier the same section 207 of CRPC used to say that accused must be supplied with all the copies of the document. Now 207 is being replaced with 230, and it says, because earlier there was no time factor, that how much time it will be taken and when the accused or victim or the informant will receive the copy. There was no time. It may be 1 month, 2 months, 3 months, 4 months, on and on. But now, in order to expedite the trial process, because this is one of the important ambit of audi alteram partem, even accused as well as victim should know that what charges or what allegation has been made against the accused. But there was a delay in getting the copies of the evidences or copies related to the trial. Here, under section 230 of B.N.S.S, within 14 days from the date of production and appearance, whosoever appeared and produced any document relating to the accused in the court has to supply the document within 14 days from the date of the appearance. Now this will trigger and expedite the trial process. This will give the opportunity to the accused to prepare his defense also. Now section 193 clause 9, that B.N.S.S provide investigation during trial with permission of the court to be completed within 90 days. Now this is very good recovery, you can say good initiative. That earlier it was that once investigation has been completed, entire investigation report has to be completed and submitted to the police. Now in between, during that process, if something new things come, something new evidence has taken place, now how it has to be reported, that was a factor. So during trial also police can investigate the case, and if something new thing come during the trial, suppose witness has been harassed, suppose witness has been tried or attempted that there is a danger to the witness, there is tampering with the evidence, and now victim wants that to show the trial court that evidence is being tampered. So during process of trial there was no procedure. This section 193 clause 9 says that during trial also investigation can continue, but the only rider is permission of court is required. And if you initiate or start investigation during trial, if police start investigation during trial, that has to be wrapped within 90 days, because the evidence is of no use if trial has concluded. Don't you think that when trial has concluded and you get a game changer evidence, you can't put before the court because now trial has concluded. So now this again liberty and flexibility has been given under section 193 clause 9, that during trial also investigation will continue. Only thing is that you need to seek permission from the court, and the second rider is that investigation must be completed within 90 days. So this is again a welcome initiative. Now section 193 of B.N.S.S time bound completion of investigation within 2 months in offences of rape and POXO cases. Now major criminal amendment has been made in year 2013, 2018 regarding the offences against women, regarding offences against child. Because after Nirbhaya case, you all know that our criminal justice delivery system became more and more strict, and new amendment has been made. Keeping that amendment in mind, Bhartiya Nagarik Suraksha Samhita has taken that all the offences relating to rape cases and POXO 2012 has to be completed, all the investigation has to be completed within 60 days, because it is the victim is being harassed, victim is the utmost sufferer in the case, and you all know the situation in the country that National Crime Record Bureau has released the data that how many rape cases and POXO cases has been alleged or taken place in the country. So in order to put full stop on such crime, this initiative has been taken in the procedure. Now again see section 193, time bound progress to be informed within 90 days to the victim and informant. Now this is something which makes a citizen centric, victim centric procedure, because police never used to inform the informant. Have you seen or heard that police has come that see I am informing you that this work till now I have done? Never. And who is in the question? Who is the utmost sufferer in the criminal justice delivery system? That is the victim or informant. But nobody was there, no system was there to inform. They used to come and ask कि मेरे केस में क्या हुआ है, दरोगा जी बताइए कितना इन्वेस्टिगेशन हुआ है, कुछ जानकारी नहीं मिलती थी. But now you see in section 193, it is the duty of the police to inform the victim as well as informant about the updates which they have taken progress in the investigation. They will go knock the door and inform the informant and the victim that this much progress has been done in your case. Now this also proves that Bhartiya Nagarik Suraksha Samhita has taken common person or common people idea that they have a right to know about their case. They must be informed by the police about their case. And this is one of the initiative, or you can see a game changer, that section 193, time bound progress to be informed within 90 days to victim or informant. Now this is something very important state of affairs which has to be worked on. Then you can see section 184 of B.N.S.S. We have already discussed that in case of medical examination of a rape victim, that is section 164A of CRPC, now section 184 of Bhartiya Nagarik Suraksha Samhita, which says that within 7 days, registered medical practitioner should give the medical report to expedite the investigation in rape cases or POXO cases. Here POXO is also there. So now section 185, copy of such report not later than 48 hours submitted to magistrate. Now this is again a very dynamic concept. As I was mentioning, that there are huge number of false cases where police plant unwanted materials, and in such they say that from your house drugs has been found or any unwanted material has been found. There are number of cases pending in the village where people are victim of false cases. Now in order to fix section 105 of B.N.S.S, as well as please read section 107 of B.N.S.S, that a new methodology has been adopted, or we are in process of adoption, for which the infrastructure is being prepared. That entire search and seizure procedure will take place in audio video recorded format, and that audio video recorded format within real time, the maximum time is 48 hours, must be sent to judicial magistrate. It is not for keeping. They have to inform the magistrate that we have done search and seizure on that house in that case, and this is the report. If they delays, it will challenge their authentic work. Police will come in the question that there is certain foul or mischievous activity has been done by police. Now here you cannot escape. Police cannot plant while doing any audio video recorded mechanism of a search and seizure. So this is again a welcome initiative under Bhartiya Nagarik Suraksha Samhita, and let me tell you, entire state police mechanism is being given with a special mobile phones for recording. It is not for their personal purposes. We are in process of creating that infrastructure that supports audio video recording mechanism, because it is purely a digital and high technological advancement used in criminal justice delivery system. It has to be utilized, because we are already witnessing Digital India program. Lot of achievement has taken place. So this is once again in order to fix transparency, in order to fix accountability on the part of police. It has been done that during search and seizure, means entire sections which are involved has to be done. Now you see, I think this is the most unused provision in CRPC. Why I am saying? Because it was introduced in year 2006 in CRPC, section 265A to section 265L, chapter 21A of CRPC, the concept of plea bargaining. Now let me tell you, this is very rare case falls under the plea bargaining concept. And we are focusing that it has been introduced that there will be a mutual resolve of criminal cases, but it hardly achieves the target by utilizing plea bargaining, because earlier plea bargaining was free from the clutches of time. How much time you can take, whatever time you can take, there was no time limit factor. But again, the wider interpretation of plea bargaining has been given. First, on the part of plea bargaining involving the question of child. Earlier, it was not allowed, because below 14 years cases was, if a person is below 14 years, such cases will not be covered under plea bargaining. Any cases of above 7 years or death penalty will not come under the clutches or ambit of plea bargaining. Now, B.N.S.S has extended the scope of plea bargaining. How? It has fixed the time limit. That, what is the time limit? You can see that B.N.S.S has defined the word that has been defined under IT Act also, the word child. Now, earlier provision clearly write that plea bargaining will not applicable. You all know in rape cases there can be no plea bargaining. In murder cases there can no plea bargaining. Plea bargaining can only be done in less grievous offenses. It can only be done in less grievous offenses. The basic jurisprudence is that the cases of petty nature can be resolved through plea bargaining. But it is hard reality that we have utilized the concept, though it is there in the statutes. But now we see this plea bargaining concept. Now you see, plea bargaining concept is based on MAD, participation of police also, and the report will be handed over to the judge. Plea bargaining, this case must be resolved with plea bargaining, then it will move on. Now this was only, there was no time limit factor attached. Now here you can see, the earlier in the absence of time there was misuse of time by accused. They usually file the application of plea bargaining to avoid judgment. On the day of judgment, he has filed an application of plea bargaining. Now, this has halted the process of judgment, because Section 265A writes accused at any time before judgment. Now, at any time before judgment means on the day of judgment he files an application. Now, it will delay, because earlier there was no time limit factor. So, it used to delay. And it is most unutilized part of the criminal justice delivery system even today. But the challenges was there was no mentioning of time limit. So here the time limit has been provided under section 290, that the application of plea bargaining may be filed within 30 days from the date of framing of charge. Now you see this very interesting fact, that after framing of charge, court will wait for 30 days. within, if you have exhausted that 30 days, you cannot file plea bargaining. Now this delay or misuse can be stopped, because very intentionally now you cannot enjoy the flexibility of time, because there is a time limit factor under section 290 of Bhartiya Nagarik Suraksha Samhita. Now this time factor again bounds that a person or accused, and you see accused are so smart, they want to find all the gates which are opened by the law, and they misutilize. On the day of the judgment, they will file the application of plea bargain. Now they cannot do so, because now there is a 30-day from the date of framing of charge. After framing of charge, court will wait for 13 days, 30 days, and if no application, then the further process will proceed. Now after that time, you cannot file the application or utilize the concept of plea bargaining. Now section 265B does not specify any time limit, the earlier one of CRPC. Now this section 294 of B.N.S.S specifies, even again there is another time limit, that public prosecutor after filing an application of plea bargaining should not exceed 60 days. Now even the plea bargaining is filed, maximum within 60 days it has to be wrapped up. So from beginning to the end, all fixation mechanism has been used to stop the misuse of plea bargaining and enjoy the benefit. So that part, it cannot be utilized. Now you can see the valuable additions which has to be made. Now we have section, these are the very important section, and I will request you to just keep eye on these section, because these are the whole thing which has to be summarized, because there are 39 chapters in Bhartiya Nagarik Suraksha Samhita covering 530 sections, which is a very big deal. And the major thing which we have to do right now is only the comparative study, because you all and we all are going to know that now we only have to get ourselves up to date, that what changes has been done. The only thing what we have to do is to keep ourselves up to date, that what changes will take place after 1st July 2024. And this will help you in looking after and resolving the trial application at the jurisdictional level. Because now you see, now first class judicial magistrate pecuniary fine limit has been enhanced to 50,000. So this is one of the change. Second class judicial magistrate pecuniary fine has extended to 10,000. Earlier it was 5,000. So now the pecuniary limit has also been enhanced. Now you can see witness protection scheme. Earlier, as I said, witness protection scheme was launched in year 2018. Now, if you will find the law, there was no law on witness protection. Why? Because Honorable Supreme Court in state of Gujarat versus Anirudh Singh laid down certain guidelines that witness protection scheme should be launched. Witnesses are very important part in trial, plays very important part in trial. They must be protected. And witnesses are most vulnerable people after victim. First vulnerable people is victim, and second vulnerable person is witness. Because if I am witness to a murder case, then I am on the target. And there is nothing to help me, because I am not a person holding the post and I am getting 2 bodyguards. And I am very much vulnerable, because anyone can come and hit me with bullet, because I am going to, as a witness, to produce my statement, to record my statement in the court of law. And we might have seen in the news every time that in the court or in the house that witness has been kidnapped. Witness has been targeted. Now, in order to fix the criminal justice delivery system, witness must be protected. And earlier, we had no statutory backup for witness protection. Now you can see in Bhartiya Nagarik Suraksha Samhita, section 398 exclusively expressly mention about that duty of the state government to ensure protection of the witness. Now this is the game changer. I am not saying, because we are already having the Vulnerable Witness Protection Scheme 2018, but schemes are having no legal binding application. You all know that unless and until law is not binding, people are not going to obey. We have huge judicial precedent. We were governed by Vishakha versus State when it comes to the protection of the woman or sexual harassment of the woman at working place. But 2013 we got a POSH Act, protection of women from the sexual harassment. Why? Because guidelines are not going to work very effectively as statutes work. You must have a binding, though Supreme Court judgments, Honorable Supreme Court judgment is also binding. You can see and check, even today, the DK Basu case, how many police stations are going to follow the guidelines of DK Basu? Don't you think it is being properly followed? It's not. You can check anywhere. There is no visual display of the rights of the arrested person. So we need a legal backup with deterrence also, with punishment also, with strict compliance, because it is the requirement that our justice delivery system, our society favors the binding character of the law. Now you see, we have already seen 0 FIR and E-FIR, right to get free copy of FIR to the victims. Earlier, we need not to explain. No withdrawal without victim hearing. Now this is again a very, very interesting. Earlier, withdrawal of case was used to take place without consent of the victim. Prosecutor used to file an application that we want to withdraw the case. And nobody used to ask the victim that, okay, do you really want to withdraw your case? And victim was helpless. Now section 360 says, without consent of victim, no case can be withdrawn. Now this is one of the major breakthrough that was required in the form of section 360, which was similar to 321. 321 was not allowing the idea of victim. The consent of victim was not present in section 321. But in B.N.S.S, that similar section is there, that is section 360, which says permission from the victim, that victim must be taken into the account before withdrawing any criminal case. So this is again what proves that this B.N.S.S is a citizen-centric approach. Then you can see, as per section 63, summon can be issued in writing or in encrypted. Now, a very interesting thing that on WhatsApp, through electronic mechanism, summon can be issued. Summon can be served through WhatsApp also. So these are the because you see, summon is very important part in the judicial proceeding. Summon plays very important role, and therefore now section 63 of B.N.S.S, section 64 of B.N.S.S, now the thing that is section 356, for what we were waiting. The trial in absentia, the new addition to Bhartiya Nagarik Suraksha Samhita, which says even if the accused is absconder, proclaimed offender and absconding, trial will continue. Judgment will also be passed in absentia of the accused. Judgment can also be passed because accused or the criminals were taking the benefit that if I will not be before court, how trial can move on? And they used to enjoy the flexibility of the time. They used to enjoy the flexibility of the loopholes of the law. And now that loophole has been blocked with trial in absentia under section 356 of Bhartiya Nagarik Suraksha Samhita. Now again one major addition is, earlier you might have seen that person has been given death penalty by the court, and for 5 years his case is pending for mercy petition. And until the mercy petition is decided, nobody can hang or proceed with the death penalty. Now that has been also taken into account, and time fixation has been given that section 472 is new addition relating to mercy petition, that it was introduced for the first time. Limit has been fixed for filing the mercy petition before the governor and the president. 30 to 60 days has been given. It will prevent misuse of mercy petition. Earlier, what mercy petition was like a victimization of an accused. Person has been given death penalty and he is waiting for final approval from the government for 5 years, for 3 years, for 2 years. Now, and finally, because of that victimization, his death penalty was being cancelled. Because you cannot, as from the human rights perspective, now you can also not enjoy the liberty of time, because even the mercy petition, I don't know how it will be followed. The onus is on the president and governor to decide. But they have also a role to play in criminal justice delivery system. And therefore, this has been added under section 472. Only time will tell how much effective it will be. Now, under section 530 of Bhartiya Nagarik Suraksha Samhita, there is a trial which will go, all process of trial will be online, which I was discussing. So these are the major thing which has to be taken into the account. Now let me take you to the part of this comparison chart. This comparison chart is very, very important, because you see this comparison chart will balance the equation of right now existing CRPC 1973 and what are the new additions, because there are number of provisions for audio, video and electronic mode of the evidences, search and seizure mechanism, then the witness protection scheme and the disposition. So this set what we have missed earlier, let me bring to this part only. Now this is certain thing, because the concept of bail, which is very, very important, that highlights the importance that these changes are required in line with. Now what are the additions in Bhartiya Nyay Samhita? Because you see, new punishment has also been added. What are the new punishment? We have added organized syndicate crime. We have added a new crime, that is terrorism. Cyber crime has also been expressly mentioned in the Bhartiya Nyay Samhita, and chain snatching. Chain snatching was not earlier. Now we have the provision for mob lynching cases also. We already know that section 124A sedition, you might be knowing, that has been removed. Now sedition from 1st July will no more longer will be a crime. Now what replaces sedition? Because this type of trial, because this Bhartiya Nagarik Suraksha Samhita has taken into the place special laws also, that all the special laws will be guided by the Bhartiya Nagarik Suraksha Samhita. For example, we are having the POXO code, we are having SC/ST code, we are having CBI code. Do you find that place in CRPC that it expressly mentioned about the POXO code, it expressly mentioned about the CBI code? Anyone? Have you seen the provision of the special court in CRPC? No. These are the specially designated court by virtue of a special enactment. For example, POXO court says the establishment of a special POXO court will be the court of session. If you will go to the POXO Act 2012, you will find out there are the special courts, creation of special courts, creation of child-friendly courts under the POXO, and that belongs to the court of session. Now that court of session is the special court under the POXO, which will be utilizing all these timeline factor for Bhartiya Nagarik Suraksha Samhita. So one thing that Bhartiya Nagarik Suraksha Samhita has expressly done, it has been, or it act as a bridge with other special laws. Earlier, there was no mentioning of a special acts, but this Bhartiya Nagarik Suraksha Samhita mentioned about the POXO directly, such that uniformity can be reached, uniformity from the subordinate court to the higher court in same process to expedite the criminal justice delivery mechanism. And the root of the center or the center stage is victim centric. So we have to know that why these changes has been made, because so far as since operation of 1973 CRPC, we have not gained much, because see, 70% of CRPC is still existing in the form of Bhartiya Nagarik Suraksha Samhita. Only 30% amendment has been made. And what these amendments are, basically these amendments are basing on the timeline. The major, if it is a case related to POXO, if it is the case related to rape, if it is case related to summary trial, major enhancement has been done in summary trial also. Now what has been done in summary trial? You see, summary trial pecuniary limit has been enhanced from 2,000 to 20,000. Please note it down. Summary trial enhancement, because that is also one of the major, if you all can recall, summary trial procedure has been, there is lot of change. Two things has changed. What? That is the pecuniary level limit, that is earlier up to 2,000 has been extended to 20,000. Plus 2 years of imprisonment or offense relating to 2 years has been increased to 3 years. These are the basic and very fundamental change which has been done in the procedure of summary trial also. And for the first time, clear-cut classification of offences has been made. Earlier also there was compounding of offences, bailable, non-bailable, cognizable, non-cognizable. But this time it has come with the demarcation of high gravity criminal cases and medium gravity criminal cases and less gravity criminal cases. And accordingly the accused will be tried, and there is the widening the scope of summary trial, because widening the scope of summary trial will enhance the expedite and speedy justice delivery system, now which is required to be done. Now let me just show you something which will put more light. Now these provision, that is the compulsion from the victim perspective, you can see we don't have, even if we talk about the state of Bihar, how much cases are being investigated and examined by forensic science laboratory. How many cases? I think very less number of cases, because high profile cases, earlier we used to see only high profile cases were subject to forensic examination. But now, from saving the interest of common person who are the victim of heinous crime, where somebody has, poor person, children has been raped, poor person has been killed. Now, in order to investigate such case, there is compulsion that any offense involving more than 7 years will be tried or investigated by, compulsorily investigated by forensic science laboratory. And there will be a scientific expert who will be investigating the case, examining the case, and will be sending report to the police station, means police, and police accordingly will submit to magistrate. Now let me just see the other provisions of this very important dimension which can enhance, that is the part of committal. This plays very important role. Now entire system at right now is fixed and halted during the provision of committal. Now these changes, these major breakthrough has to be done and has to be carried out in order to make. And let me tell you, extrajudicial, extraterritorial application of B.N.S.S. read with Bhartiya Nyaya Samhita. Now if any person who is committing crime against India outside the Indian jurisdiction, there is a clear-cut application of extraterritorial application involving cybercrime. A person sitting in America is targeting Indian land for terrorist activities. He can be easily fixed under Bhartiya Nagarik Suraksha Samhita plus Bhartiya Nyaya Samhita, because new addition, new punishment has been, new offences has been added in Bhartiya Nyaya Samhita. Read with Bhartiya Nagarik Suraksha Samhita, because the application of, there is a widening scope of definition that the words which are not mentioned in Bhartiya Nagarik Suraksha Samhita shall be dealt if it is mentioned in the special laws. Now this is what we are looking for, because Indian criminal justice delivery system often search for new definitions. We used to say there is no definition of bail, there is no definition of victim. Now section 2WA, victim, was added in year 2009, but it was not so effective because it is only for the namesake. But now victim enjoys same right as informant. Earlier victim were not provided with the FIR copy. Now it has been express provision that with informant, victim will also receive the copy of an FIR. Now newly added, for example, there is a crime against sovereignty, integrity, security of the country. Now that has been replaced. Earlier same crime was fixed under the sedition, section 124A. And you all know that how difficult it was to come out of false accusation of sedition. There were the young students who were charged with the sedition and they lost their career. You can't imagine the stigma that holds on a person who was charged with sedition. Because today we are no more living in colonial era and colonial mindset. There are no king. If I have not given dignity to that king, I will be charged with sedition. Now that has been replaced with section 153 that talks about section 153 of Bhartiya Nyaya Samhita. What is that? A person if commits offense against sovereignty, integrity and security against India. Now sedition has been replaced with that section. Now sedition is no more crime. Now we often used to hear about the chain snatching cases. There was chain snatching was booked under theft, which was a wrong interpretation. Now there is addition that chain snatching is also a crime. And if it is snatched against a woman, it is also crime against woman. So these new additions are the need of the time. And because of this, these amendments were made, and now there is no amendment, a new law which has been proposed and notified, and from 1st of July we are going to see and witness. Right now we are in transition phase, because a lot of confusions are there that what will happen, all new laws will come. No. New laws will be applicable from 1st of July for new cases. It will not be applied on old cases. So be clear from the jurisprudential aspect that how, when to utilize what. And for that purpose, this deliberation of addition, deletion and comparison of CRPC with Bhartiya Nagarik Suraksha Samhita. So I have covered all the part from pre-trial, session trial, summary trial, warrant trial, that what new specific thing and latest development has going to be taken place. And you can include such all with that, because we should, as a citizen of this country, we are under the mandate to know both the laws, because both the laws are the need of the time, because we cannot ignore the present and we cannot ignore the future. So that is why this comparison has been made. Now the floor is open for the question and answer session. We are left with only 5 minutes. So if you have any question or any confusion relating to this Bhartiya Nagarik Suraksha Samhita with respect to definition, because see, in 1.5 hours, I have given you the gist of entire organization of the section provisions and gist of all the changes, because these slides I will share with sir, and sir will or ma'am will circulate to you all, because these slides focus on the same, because nobody has time to read all the sections. So what it is meant, and that is why this deliberation has been organized, and the government of India is carrying out the training program on these new laws in order to sensitize and create the capacity building such that we should be in position to utilize and know that how much effective these laws are and how more effective we can do, because you are the direct stakeholder. As a judge, you are going to look after all these things, so it is better to stick to the mandate and the procedural mechanism which has been discussed. And I will request ma'am to share these slides to all the participants and learned judges, such that it can be mostly utilized, and it is onus on you also to sensitize others also, sensitize the lawyers also regarding the new Bhartiya Nagarik Suraksha Samhita, because from 1st of July we will be in new criminal justice delivery system, and both old one and new one. Onus is that we have to know both. We cannot ignore the past and we cannot ignore the future. So with this gist, I come to the conclusion of this, and floor is open. If anybody is having any question, you all